6. If you would, all please stand and join in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Okay, Mr. Glancy, when you're ready, give us a roll call for attendance, please.
Michael Duke.
Present.
Andy Ellis.
Here.
Lois Jones.
Here.
Chad Kirkpatrick.
Here.
Sandra Rowland.
Present.
Wilbur Webb.
Here.
Ed Hartman.
Here. Thank you. Okay, next on the agenda is approval of the minutes for February 2nd, 2026. Are there any corrections or additions to the minutes?
Mr. Chairman,
Yes.
I did not receive those minutes, but I was not present at those at that time. I had not been sworn in, so I don't know that I need to see them.
Okay, thank you.
Now, they were emailed, but they weren't in the packet.
Okay, if we're ready for a motion,
I would move that we approve the minutes for February 2nd.
I have a motion to approve from Mr. Duke. Do I have a second?
Second.
I have a second from Mr. Webb. We have a roll call vote, please.
Michael Duke.
Aye.
Andy Ellis.
Yes.
Lois Jones.
Yes.
Chad Kirkpatrick.
Yes.
Sandra Rowland.
Yes.
Wilbur Webb.
Just,
Abstain.
Motion passed.
Okay.
Next on the agenda is approval of minutes for April 6th, 2026.
Mr. Chairman, I will note one misspelling in item 5.1 under new business. My last name does not have an I in it, so that could be corrected, please.
Yes, okay.
Oh, sorry about that.
Mr. Chairman,
Yes.
same one, my name is misspelled also. It's A-N.
A-N.
Same
Okay.
line.
Oh,
Okay, are there any other corrections or additions to the minutes? Okay. I'll entertain a motion to approve with corrections.
I make a motion to approve with corrections.
Second.
We have a motion from Mr. Ellis, second from Mr. Duke. Would you give us a roll call vote, please?
Michael Duke,
Aye.
Andy Ellis,
Yes.
Lois Jones,
Yes.
Chad Kirkpatrick,
Yes.
Cindy Ron,
Yes.
Wilbur Webb,
Yes.
Motion passed. Okay, old business. Update for Jack Heimlich docket 018-25. Will you approach the podium, please, there, Jason Miller?
Yes, sir.
You're right, sorry. Hit the button here, is it on?
I don't think any of them are on.
Well, then I'll speak loud.
Okay.
the batteries must have ran out.
I'll sign in as Mr. Glancy's handing out the exhibit showing our progress.
Thank you.
And I'll fill out the rest of that as we're going.
Right.
What is presented before you is an aerial photo along with the progress of the topographic survey that we've completed and working on the preliminary design based upon your input from prior meetings. And what I'd like to summarize is a couple things. As I'm moving stuff around. So we have reviewed all the various standards for the new board members. I don't know what knowledge you have on the case, so I'll kind of get you up to speed as it relates to the history. This is a site located just to the southwest of Upland. It's the Jack Heimlich gravel property. The standards in the zoning ordinance require a couple different things. Number one, compliance with the floodplain ordinance. And just for your new board members and for the record, I am a certified floodplain manager, a professional engineer in Indiana, and a professional land surveyor in Indiana. The second item that we are tasked with is compliance with a 300-foot buffer from the roadway. And the final standard is 500 feet buffer from any residential buildings. So a couple things that I will comment on. Number one, the floodplain we are able to comply with in its entirety. Any work that we would do, subject to what that definition is once we come to a final plan, which I'll talk about briefly here in a bit, would comply with that floodplain ordinance. The goal would be to prohibit any placement of material inside the floodplain and thus eliminating the need for any floodplain permitting other than a local floodplain permit that's handled administratively with the county plan. The next item I'm going to jump to is the 500-foot buffer. And the reason I'm going to do that is because that is the more restrictive standard when comparison with the 300-foot standard from the roadway. So the 300-foot is inside that 500-foot given the location of the residences in all locations across the frontage of the property. So that technically doesn't apply. If it does, we still meet it. And now, most importantly, you'll see 4 or 5 circles from the adjoining residential properties. Those radii are 500 feet. So that limit shows the distances 500 feet from the nearest residential structure on all adjoining properties, anywhere near the property that would be in question for Mr. Heimlich. So technically, anything inside those circles would be within that 500-foot buffer, and the material that has been placed over the last 20 to 25 years technically would be inside of that location. So in the past, what we've discussed is let's come up with a plan that meets everything that we can, and if it doesn't meet, then the special exception would then authorize whatever the board would or will determine to be waived from the requirement would then be approved if you so chose. What I'm presenting today is our first rendition as a means to kind of compromise and meet in the middle. And primarily that is because if we are required to comply with all 3 of those standards, the material that's on the property cannot remain on the property. It would have to be physically removed from the property. And if you've been by the site, you'll understand. If you've not been by the site, I encourage you to do so. You're talking 20 to 25 years of material. It will take an estimated 10 years to remove all of that material. If you have a lot more trucks and you're using a lot more equipment, then obviously, yes, it can be done in an expedited manner. But generally speaking, if you take 20 to 25 years of material that's been placed there, it's going to take about 10 years to get all of that removed. So we believe that that is a hardship and that we are asking that some of that material be allowed to remain inside of that 500-foot buffer. We are going to comply with the floodplain, so that would not be an issue for the standard that we can't meet. So the remaining item would be, can we leave material inside that 500 feet and also the 300 feet? What is currently proposed is you see the hatch area on the far east side of the property adjacent to the roadway. That is the area that is 50 feet wide from the edge of the pavement back to the west. We are proposing that all of that material in its entirety be removed to create a 50-foot wide buffer from the roadway, and all of that material be removed and placed on the property immediately to the left or to the west of kind of that middle circle. And it says all material to be relocated and redistributed to open areas outside the 500-foot buffer. So that note there in the middle is where we would propose to place that. That is outside the floodplain. It is also outside the 500 feet and also then the 300 feet limit. That is a best concerted effort that would remove what I would consider the most hazardous material up against the roadway and provide a little bit of a buffer from the people traveling the roadway as well as the residents. And you'll note in the lower right-hand corner of our exhibit on sheet C100, note number 4 specifically says an earthen mound with a minimum height of 8 feet shall be constructed along County Road 825 East with vegetation to provide a buffer from the roadway. The intent would be for anybody that is walking or riding a bike or driving a vehicle, that if you are on the roadway, you can't see the large pile that would remain because we've removed 50 feet of it. We then have placed an earthen mound and created vegetation on there that would provide a natural buffer. So if you are in a home and you're on a second story or on the east side of the road, will you still see it? Probably. But you've seen it for the last 20 to 25 years if you've lived there that long. If you didn't live there that long, then this condition existed prior to when you purchased your home. And I didn't go back and research when people purchased homes. I don't think that's necessarily prudent at this point. But my argument is that this has been going on for 3 executive directors or more. And now this board is tasked with a decision that this administration and executive director has brought before you, and the petitioner is willing to cooperate and find that common ground because we cannot comply with all of the provisions of the ordinance. Hence the special exception request for the operation that's ongoing on the property. So a couple of final points just for your consideration, and then I'll wrap up and answer any questions that you have. Work has stopped on the property. They are not bringing any more property or any more material onto the property. What we believe, and I didn't get a chance to go back and look at the prior minutes, but what we believe the ruling was, I think in February, was that we can take material off, but we cannot bring any material on. If that is not the case, please advise me and I will let my client know. But I believe that's how we left it. They have removed material from the property. They've told me they have not brought any on, and the office knows that no material can be placed on the property now that a stop work order is in place, and we are honoring that. If we are not, please let me know. The second item is we've closed access to County Road 825. That access was closed immediately following, I think it might have been the December or maybe the November meeting. It was the next day, as I brought up in a prior meeting. That access will remain closed indefinitely. It will not be reopened as a part of this project. That is a commitment that the landowner will make not to use County Road 825. All access to the property, should you allow this to continue, will be from the north gate. And then finally, we're working with the agencies to permit at the state and federal level, and then also the local permitting that would be done here with area plan. And we are also providing regular updates. I apologize, I could not make the last meeting in April. I had a conflict. I was here in March, if you recall. However, the meeting went forever, and we just did not get to this topic. If there's any more information that you'd like, or if you'd like regular updates, I'm happy to provide them. My request this evening would be to not get an official ruling, but to get maybe some unofficial guidance on what you think the proposal is, if you think we're going down the right road. We have done a design based on what is presented before you, and it does meet from a hydrologic and hydraulic perspective. If we modify that, I have to go back in and change that report and then present whatever findings would be applicable for compliance with all the rules and requirements from local, state, and federal. So I said a lot. I tried to cover a lot of ground for you as a brief update. I'll probably have to repeat some of this next meeting, but happy to answer any questions if you think I'm in left field, or if you think this is something that maybe would be prudent for a hearing, then we will certainly proceed with that information over the next month. It will not take us a month to get that completed. The petitioner is requesting that we do get this done in an expedited manner so that you guys are satisfied and they are satisfied, and hopefully the neighbors are satisfied. With that, more than happy to answer any questions.
Okay, do we have any questions?
I have one. You mentioned you were going to, and again, you're exactly correct. I wasn't here when this all happened or started. And you mentioned you were going to go get state licenses or...
Correct. Permits?
Yeah, permits. Will that override our county ordinance?
No, it would be a layer on top. So a couple of the permits that would be required. If we're working inside of the floodplain, we would need a floodplain permit through the Indiana Department of Natural Resources, Division of Water. I work with them regularly. Because there is more disturbance of an acre or more, we will also need a construction stormwater general permit. That is formally referred to as Rule 5. It is now a CSGP with IDEM, the Indiana Department of Environmental Management. I file those monthly, if not more frequently. So those are the two permits that we would absolutely need. And then we would also need to provide copies of those permits to Mr. Glancy's office, and then file a local permit that his office would issue if we meet all the rules. We can't do that until this board acts that the use for the special exception is consistent and approved. Then we would file all those permits.
On the 50-foot setback.
Yes.
Road, you said you're gonna have an 8-foot berm. Is that berm gonna be your 50-foot setback and then your 8-foot tall berm, or?
It would be inside that 50 foot.
Inside 50
and
foot.
what I would prefer is it be closer to the roadway, but we don't show it schematically because I would like for your input on what you guys would prefer. The closer it is to the roadway, the more buffer it provides. I don't really want it out at the 50-foot line. I would prefer to have it set back a little bit off of the road for safety in the event of an accident or lane departure. Then that vehicle can recover, probably about 15 to 20 feet, and then start that 8-foot high berm, and it would take up about 2/3 of the remainder of the land of that 50-foot swath. However, again, if you guys say, hey, we would prefer it to be closer to the road or further away from the road, we have complete latitude on what we can do inside that distance.
Okay.
Is the proposed berm just in that 50-foot shaded area there? Or does it go the length of the property?
It is so that is the length of the property would be that strip there as shown.
Yeah.
So it starts at the creek on the north bank.
Yes.
And then goes north to their north line.
What's the plan for road repairs?
I don't have that answer specifically, but I do know that we had initial conversations with David White, County Highway Superintendent. He's aware of the issues. I think the question and concern becomes, whose responsibility is it? It's certainly not, in my opinion, the county's sole responsibility, but I also don't know that it's entirely, Mr. Heimlich's responsibility, because he wasn't the one driving the vehicles damaging the roadway. So now the road needs fixed. So at the end of the day, I think we need to work closely with County Highway to determine who's going to repair it and who shares in what cost. One of the things that I talked with Mr. Glancy about is trying to get NDOT to repair that roadway, because we can argue that some of the damage was done as a part of their bridge project. Therefore, the contractor on their contract would be at least partially responsible for that. Now, whether or not that goes anywhere, we don't know. What I can tell you is having involvement with Upland, we are currently negotiating with them on repair of 8th Street, which was the detour, which if you've been in Upland and seen 8th Street, it's destroyed. So hopefully NDOT will cover all or most of the expense for the town. And the question then becomes, will they then also include the damage to 825? I can tell you it will get fixed. I just don't have any authority to determine who gets what percentage of that cost.
Yeah, now, I assume Mr. Heimlich opened the driveway into his property?
On the east side or from the north?
No, off of this road here that's all damaged.
I would assume so. And I think let me go back and check
Otherwise, they would have had to come in his normal entrance.
Correct. I believe.
Note number 1 says the existing driveway on 825 to be removed.
Right. I think his question is who put it in and when. So it is shown on the August of 2010 aerial photo. So it's been there for at least 15 years. When did it go in? I don't know, because the September of 2005 aerial it's difficult to determine if it's there or not. It looks like it is, but I can't confirm. So I would just estimate sometime between 2005 and 2010.
Yeah, go ahead and pass that around to the board.
And this packet of information will be submitted when we have the next meeting. And you're welcome to them now. I can make more copies.
Now, the activity probably really ramped up with the bridge project in Upland.
I think that's an accurate statement.
Were there any permits for what roads they would use?
I don't know about what roads, but as a part of, I do work with NDOT. I'm an engineer working with NDOT, certified through them. So part of projects, when you have roadway jobs like this that NDOT manages, you have to file for certain documents if you want to have an off-site dump site. Those documents were submitted and approved by both NDOT and IDEM. I've requested copies both from NDOT and from the contractor. Both indicated that they do have them and they're willing to give them, but they really don't want to get involved in, a lawsuit or an argument, a disagreement of any kind, because they manage the road project. I'm working to get them, but as of tonight, I don't yet have those. I have a copy that was completed and not signed, but I can tell you before NDOT allows material to be hauled off-site, the inspector for that project is obligated to visit the dump site and sign off on it. I can only presume, and it is only a presumption, that did occur. I have no evidence that it did or did not, other than the contractor's word saying, yes, we have it. We just really don't want to give you a copy of it. So I'll get a copy. The question is, how do I get it? I'll find a way to get it, and I'll have it for the next hearing.
Don't they usually choose a route for the heavy trucks to travel?
Not necessarily, but they will primarily cover, highways, but in this scenario, it's county roads. So that's more of a contractor specific item than it is a designer. And my role with NDOT is design on projects, so I don't have that answer, what they did or didn't choose.
So, okay, that's what we need to find out
Sure.
then, if there was a choice.
And I tried to get it after my meeting with Mr. Glancy today. I tried to get it for the hearing. I don't have enough time to get it. I've asked for it twice. We'll get a copy.
And this is all going to be in compliance with the floodplain,
Correct.
the creek here?
If you were to approve or at least tentatively say, yes, we think this makes sense, then I can finish things. What I don't want to do is put a bunch of effort into the design and calculations for then you to say, well, we don't want this. You have to remove everything within 500 feet. So if you think, and again, I don't know what level of approval / guidance that you guys are willing to offer tonight, if any, and I'm certainly willing to have additional meetings in the future as necessary, but we do want to get this cleared up so it's off your docket as well as the petitioner. So if you think that that 50-foot setback is acceptable, we will then finish the plan. We will present that at the next meeting, and if it is approved, we would ask for approval subject to the permitting agency's blessing. We then would get the permitting from those agencies and then turn it over to county planning. They would then have the final say on issuing a local permit and compliance with your order.
Now, is the mound, what will it consist of?
Well, it would be earth, it'd be dirt, topsoil.
Dirt,
Yes.
not concrete and asphalt and bricks?
Correct. All of the material inside of there would be removed and placed outside of that 50-foot setback, and it would be mowable and visually appealing. If you want trees or shrubs or a fence or whatever you guys may want on top of that or on the side of it, I mean, that's well within your purview to add those conditions.
Looking forward to future use or plans that the Heinlein Company has for this tract inside or within the boundary, that how are they looking at planning on using this tract of land?
So they've not specifically told me that answer. I've not specifically asked it to my recollection, but one of the things that they did mention to me is they want to take the material off-site because it's sellable. They want to generate revenue by hauling that material off-site. They are aware that they can't bring new material on-site and place it in the floodplain or inside that 500-foot area. So they would have to comply with the special exception order if they were to bring new material on the property. That would fall underneath the permit that I would present for your final blessing. But their ultimate goal would be to take this material and sell it for third-party use.
Okay. I know I've driven past it.
Right.
And my recollection is it's a pretty large pile of chunks of concrete.
Correct.
Or other,
Yeah, there's some sand. I think there's probably some dirt.
material. It doesn't look like there's a lot of earth there. It looks
No,
And so that's a long-term process that
Correct.
I'm looking at of removing that. I
correct.
guess my question is, are they looking at bringing any more like that into this tract of land, be it further back from 825?
If they,
It's going to be looking at removing it.
I don't know that answer, so I don't want to say one or the other, but if they were going to bring it on site, it would have to be outside the floodplain and outside that 500-foot setback. We would not allow them, the permit itself would not allow them to bring it any closer to the road than the 500-foot or the 300-foot.
And the berm that you're talking about constructing there within that 50-foot area is going to be tall enough with whatever vegetation, trees, shrubbery, or whatever, to be tall enough that it will obstruct most of the view of
Correct.
whatever material they place back.
That's
there.
correct. That would be the intent of the berm.
So the berm is 8 feet tall,
Correct.
and shrubbery or trees would be
Whatever.
that.
Yeah, and we can add whatever you would prefer. I mean, we didn't want to show trees and shrubs if you wanted a fence. We didn't want to show a fence if you wanted trees and shrubs. So whatever the board feels is appropriate to accommodate both the petitioner as well as the neighbors and the traveling public on 825, we're more than happy to entertain as a condition on the request.
And just to be clear, sorry.
Go ahead, Andy.
You require a special exception just to keep the material that's already there?
We require a special exception to do anything on the property, whether it is inside or outside of that 500 foot or the floodplain. The ordinance does not permit, according to Mr. Glancy's interpretation, the ordinance does not permit them to bring material to the site or haul material off the site without a special exception. And in as much as that statement was just made, you technically need a special exception to authorize them to even remove the material. However, the board believes, and I'll defer to Mr. Glancy and Mr. Glickfield, the board has granted latitude for them to remove material but not bring any material on, even though the special exception has not technically been granted.
And what special exception will they be applying for?
I do have that petition.
Is it to run a dump? Is it to do mining?
It is.
What is
It is both, but I will pull the exact petition. Todd, if you find it before me, feel free to respond.
So may I?
Yes, sir.
The petition that they filed on 9/15/25 was to request to accept clean fill, concrete, and asphalt with the reason the Main Street Upland Road project and disposal of the above materials.
And I think it also, I don't know if that version included it, but another petition included permitting the removal of sand and topsoil from the subject property and deposition. So, I mean, would be considered a dump site for construction debris that would either be brought in or off the property. And that would include sand, topsoil, clean fill, which would include broken concrete and asphalt, either millings or chunks, aggregate.
So from a standpoint of terminology from the ordinance, it'd be classified as a borrow pit or a landfill. Not your typical landfill.
Not a waste landfill.
Yeah. That's the terminology that the ordinance uses.
Okay.
I would observe, I'd go so far as to observe that I had set through the presentation that the Heimlich Company had made on that time back in was October, November timeframe. And my recall of that was that there were a number of remonstrators, if you'll accept the term.
Correct.
In the audience that got up and spoke.
Correct.
And they were, my general recall is they were concerned about not speaking totally for them.
Summarizing.
But they were concerned about the road conditions.
Mm-hmm.
They were concerned about the safety of their families, their children, their vehicles as they were coming in and out due to the risks that the large dumping vehicles or trucks presented to their cars or to their personages as they were out on the road. If their children were out waiting for a school bus to come past, they have concerns about that. The kind of plan that you're proposing, as I'm interpreting you're proposing, is taking all of that traffic off of the road.
Correct.
The road repair to put it back in good condition for normal access usage for the residences.
Correct.
Is important.
Correct. Absolutely. And we've already shut off access on that,
Right.
that drive. So that,
Yeah.
we believe alleviates the safety concern.
I went out and I drove this
Right.
even before December, back,
Sure.
when the immediate work, or the work, stop work order was verbalized. That's just an observation. I would expect that, it's important to hear information from the residents of the area on whether, regardless of what we think,
Sure.
what they think, what is being proposed. And if there is a hearing, public hearing for the special exception to be reconsidered, that would be valuable information, useful information for the board to factor into any deliberations.
Sure. I think the only thing I would add to that is I think you guys probably know where I'm going to go is that I can't finalize a design, which I'm fine with. I just want to make sure that the board is aware that I can't finalize a design if you do want to wait for the public hearing. And I think there's merit to that. I think the neighbors that are going to live there, they need to have their voice heard before this board gives me direction to go do a design. But I also want to make sure while we've waited, 5 or 6 months, I want to get this wrapped up. They want to get it wrapped up. I'm sure you want to get it wrapped up. As long as, the board understands that having a hearing next month, then getting direction from A, the board, and B, the public, would then give me the direction for the design. I would have to then bring it back to you. But presumably, if the public could make comments that would give you the ability to preliminarily rule on yes or no on the 50 feet or whatever number is determined, then it's just a matter of me providing a design that is in compliance with that. And then you could then authorize a special exception at that point. However, this is entirely up to you as the board to decide the next steps.
Would it be an unreasonable expectation that as the engineer preparing the design, that in the footwork that you're doing, that you would do some fact finding of your own by interviewing and talking with those residents out along that stretch of road?
I'm happy to do that.
Because of the procedures that we are in, would that be unadvisable legally?
For him to do that,
Yeah.
if he's willing to do it.
Yeah, I think I'm okay doing it. I think the question becomes whether or not you guys have the authority to do that. I'm
I
happy
don't
to do
think
it.
we have the authority to ask him to do that. If he wants to do it on his own to ease the concerns to neighbors, which seems like a good move on their behalf anyway, sure.
And I'm happy to do that. I mean, we have nothing to hide. We want to make sure that the residents, while we understand we probably won't make everybody happy, I think the goal is to meet in the middle with the residents, us, and the board so that most requests can be accommodated, hopefully all. But I think what I heard on the first 2 public hearings, they don't want it operational at all. And that's just not a possibility. So where can we go under a compromise to find that common ground if it is findable? And that's ultimately what you, as the board members, will have to ultimately rule on.
I'm wondering how much of that concern about its operation at all stemmed from the fact that they were very concerned about the safety on that road as well as the condition of the road. And if those 2 issues were addressed, would they still have the same concern?
I think we'll find out next month.
I might also add, they were concerned about the stuff there along the road. It's an eyesore. Sounds like the berm is going to fix a lot of that. And then the height of those piles, seeing them, I think was a concern also. And it looks like, depending on what you decide as far as the radius goes from the houses, they can get to work on that, maybe lower the height of those. That would probably ease their concerns also. When you look at that 50-foot berm, I would recommend having them which Mr. Miller, talk to the highway department and get a recommendation on what they believe the proper distance of that, starting of that berm from the road should be. There might be some drainage there which needs to be addressed off the road. And there might very well be motor vehicle guidelines on how far a berm should be from the road from the federal government. They have all sorts of regulations on that. I'm sure Mr. Miller knows that. And I would suggest maybe having him get with Superintendent White, and then they work together to determine the proper distance that should be from the road.
Happy to do that.
And then certainly something on top will help ease the eyesore issue also. And where it would almost be invisible from the roadway then, and then the neighbors would not have to look at it. That's my recollection of their concerns, along with the safety issues you just talked about.
How tall would you say that pile is, the big pile?
It's been a couple months since I've been out there. It's probably late February, early March. I don't really want to venture a guess because I'm probably going to be wrong, but the big pile on the south side, which is the larger of the two, is probably 20 to 25 foot tall.
Okay, that's about what I thought.
Yeah, I mean, that's just pulling a number out of thin air just based on my memory of standing on the roadway and walking around it. But I mean, we're probably in the ballpark.
It's more than a small mound.
Yeah.
Oh, it's 20.
A pretty sizable buildup.
Yes.
In my
And-
recollection of at least, well, when you say 20, 25,
Right.
at least I would say.
And historically, you can see that it is 20 years of material brought to the site, some of which has been taken off, and this is what's remaining. So you can imagine how much material has been on and off this property since 2005. And this is where we're at today. So it's a substantial volume, and that's when we started running the numbers. It's going to take a long time. I mean, it wasn't just months, it was years.
Jason, could that height be pushed west to reduce the height of that mound and get it out of potentially the 500 foot or a reasonable distance?
I mean, potentially, yes, but then you start to restrict the area that you can place new material or operate to be able to take the material outside of that 500 foot. So I think we can certainly do what the board would like, but if we push it to the north, there's an operational concern of how do you physically do that, because that material is packed down concrete and other debris. It's almost more feasible to just start to remove it, but it's going to just take a very long time.
But it looks like on this one house you have right here on the southernmost property, that particular property at 500 feet, it looks like that encompasses a good part of that tall mound. But that house also has substantial trees
The creek,
between it, so I don't know if there's even a view of that from there.
I don't know. I've not looked at it from that direction. My guess is it probably is in the few winter months, and it's not during the remaining 9 months of the year. But I don't know. I cannot answer that question.
But if you take that 500 foot circle out because of the obstructions of the trees there, then you're dealing with one more from the one across the street. And if that were reduced some, then you would meet that requirement pretty easily. It looks like then you could reduce the size of those mounds either by taking the top and just pushing it straight down. I don't know if that's feasible or not, but it looks like that might solve the eyesore issue somewhat.
And I think the question becomes, I'm not an attorney like you, but I think the board has the right to put stipulations that says they can be no higher than a certain value. So if you said it hypothetically, if Mr. Hartman and I are correct, it's 25 feet, and you say you can only place it up to a height of 20 feet, then the top 5 feet has to be pushed somewhere or taken off site. We would just want to be clear that if that is going to happen, is that permitted to stay inside of that 500 foot radius, or does that material also have to go outside of that 500 foot radius?
So when you guys, I don't know if you want to make some recommendations now, but when you rule on a special exception, remember you have the ability to put conditions on that. And you can put conditions on there about the berm, you can put conditions on there about the height, about the distance for the properties, you have the ability to do all that if you decide you want to grant that special exception. And then, in other words, that special exception is contingent on those factors.
Right.
Yeah, a lot of the concern will be, the 500-foot setback is the setback that you shouldn't have activity in.
Right.
And what setback would the board be willing to permit if it wasn't 500 foot? And
again, we're willing to keep it at the 500 foot, but only take material inside that 500 foot off-site, not bring new material inside that 500 foot area. Because again, the goal is to get the material gone.
yeah, some of the neighbors' goal is to have a little more quiet and less dust.
Sure.
Just recalling their
Yes,
testimony.
that was brought up.
So there are some things to think about.
And we're kind of in a catch-22 because yes, you could technically say do a design, and if it doesn't work, you got to redesign it. But I feel like that's a waste of time and money when we can just get to a common ground that, potentially after a public hearing is had, that you as a board and the landowners might be able to forecast what that common ground is. If not, then we may have to just put together a design and let everybody rule on that. But I want to make sure that we're doing it the right way the first time so that everybody is working off the same set of information.
So what you would like us to do is try and come up with a criteria after the public hearing, and then you can go do the design plan.
I think that would be probably the most logical if you want to consider public comment. And I think if you were to give me something now, I think we run the risk of the public saying that's not what we want.
Yeah.
So I think it's prudent if the board would permit to wait until the public hearing again to get that input and for them to be able to provide their advice on what they would want. And it might be, we don't want anything here. Take everything off the property. Then you have a difficult decision to make of whether or not you require that and deny the special exception, or you find common ground in general, right? I mean, we won't know that until we have public comment. But what I have today is a plan, I have a survey, and I have a proposal that is substantive to allow for the board and the public to look at something tangible and decide, do you like this? And if not, what do you want to see differently?
Jason, can you have them prioritize when they're starting to remove things off-site? Can you prioritize them starting on that big mountain first?
The 50-foot distance would be what is done first. That would be the immediate first action to get it away from the road.
It has to be cleared for this anyway.
Correct.
And then once that 50 foot's cleared, then you can start in on the.
Correct. Yep, that's exactly what we would do.
Because there is a lot of material close to the road.
Yes.
Unless they've moved it recently.
No, it's,
Still there.
I didn't go by today, but it was there when I was there last. And, I think to Mr. Glickfield's point, the largest height of the mound is the southeast corner up by the road.
It goes
up
back
to-
rather quickly.
Correct. So that will be knocked down inside that 50 feet. Is it going to be down to 20 feet or pick a number? I doubt it. But I also can't have a vertical face. So as we come over 50 feet, it's also going to come up at an angle, which is typically, 3-to-1 slope. So you're going to see more material than just a 50-foot vertical face wall of construction debris and concrete.
Now, is there a vertical face wall somewhere back on this property next to a farm?
Not to my knowledge. I haven't seen it, but so I'm not telling you that it's not there. I would have to look.
Do you know where it is, Mr. Glancy?
It's the sand mining operation in the very corner.
Oh, to the southwest?
Yes.
And those are vertical?
Yes, right along the property line.
Okay. Yeah, I can
It's
run
not
by.
all vertical, it's just,
I'll run by and look and take photos for the next hearing.
Okay. I've heard about it, just haven't seen it.
Yeah, I have not gone down that far. My survey crew did, and I have survey data of that, but they didn't get down into the bottom of that mining operation.
Question, sir, is, I don't know if it's feasible, but would it be possible You state that some of the materials is been there for 25 years, and I doubt that. Would it be possible to remove the material or relocate the material that was a result of the conditions that we find ourselves in today? If you were to take that material, it caused the neighbors to be so concerned and relocate that material into such an area, either on-site or off-site, then that would be maintaining what was there before.
I think, and again, I'm going to defer to your attorney. I probably shouldn't even answer this question, but I'm going to anyway. I think that you probably open yourself up for some issues if you say that you can go back and remove material that was placed at a certain date to present day, because A, how do you prove it? And B, you're then permitting a special exception that is retroactive, effective as a date in the past. Now, I'm not an attorney. That is not a legal opinion, but I think that's probably something that you'd want to talk to your attorney about, and I probably would suggest that you do that not right now on the record. But I'll defer to him.
I was just thinking about the fact that it appears like that the upland project has perhaps motivated some of this concern. And perhaps it could be.
I would say,
But you
see what the public hearing
probably
says.
right.
I mean, I'm not an attorney, so I don't know, but I think if you, I think that answer can come out at the public hearing. I think, not necessarily asked that way. I would probably advise you to talk to Mr. Linfield about how to phrase that question to get the answer that you're looking for. But I think you probably can get enough information that you can ask me if my clients are happy with the proposal, if they don't like what I've submitted, and then we can just come to that common ground. I hope I answered your question.
Hope I phrased it correctly.
We'll find out.
Question I have for you, Mr. Miller.
Yes.
If the dust from the trucks coming in outside the concern, is that something we can do through some dust mitigation or something?
Oh, yeah.
I know during the summertime, I know
Yeah.
if you're trying
Spray water.
removing trucks, removing material stuff, just if that's a concern for the neighborhood, if that's something that would be feasible to do.
Yeah, I think, a lot of factors, how moist is the ground, where's the predominant wind direction? Again, I think some common sense would go a long way on where you're bringing material in and out of. I think if you're bringing it up to that southeast corner like they were in the past, that's 25 foot up in the air presumably, so that dust is going to travel a lot further. Right. That mound is also going to help a significant amount as well. So I think there's mitigating efforts that you can do, and ultimately you may have to have it sprayed down if it's creating a lot of dust. And I expect that to be one of the conditions that you would place, is that dust cannot be excessive. Now, how you phrase your decision is going to be key, so that it's enforceable and understandable on our end, so that you don't have to enforce it. But I mean, my client doesn't want dust to leave its property. Right. He wants to be a good neighbor.
Okay,
Sorry it's taken longer
it's all right.
than necessary, but it is important that we
had some time
understand.
tonight. That's
Sure.
good. Okay, let's close here and move on.
Thank you.
Thank you. Any new business here? We have a director's report.
I gave out some material at the last meeting at the very end. Didn't know if you had any questions concerning the list of permits that were issued for January, total fees and fines, a summary of permits for 2025, and then there was an 1812 special exception report that was due at the end of the year. And I believe in that report. If you don't have it, I didn't make copies again for everyone. We can discuss those things at the next meeting also, if you'd like.
If I may, on the 1812, I think that's been annexed into Gas City, so that's a moot point.
Okay. I had heard that.
Well, I just asked Jason.
Okay.
He was completed last month, he told me. So that's part of Gas City now. It's not in the unincorporated area anymore.
But I believe they did file a report, right?
They did file a report. I wanted to ask if anyone had any questions.
Yes.
And then the other thing that I would state for the topic we just finished was next month, we'll have an actual public hearing for the Heimlich docket. Get public input. I don't think we need to vote on that. That's just what we'll do.
Yeah,
Are we good?
yeah. And remind everyone that if a special exception is turned down, they can reapply in a year.
Or they could just appeal it.
Or they could appeal it to the courts. Yeah.
Or to go into court, argue it out.
But the letters will go back out and a notice in the paper.
This will be a new public hearing.
Well, it's the same docket, same public hearing. It's just taken so long. I think it's,
Considered in last October, November.
yeah, I think it's fair to those residents that we just open it up as a, and do all the public hearing, public notices again.
Okay.
Can I ask a quick question, even though we're somewhat moving on?
We'll consider it public comment.
Perfect, I'll take that. So in an effort, and I'm not discussing this with my client because they're not here and the question got brought up a little bit ago, but I would be happy, unless my client overrules me, to provide a brief letter that staff office can include in the public hearing that says anyone with specific comments can reach out to me as the petitioner's representative, which then gets the ball rolling a little faster and somewhat more official than me trying to just track a bunch of people down. So if that's the pleasure of the board, I'm happy to draft a letter that I can get to Mr. Delancey that includes my information that he can include in the letter of mailing to the affected landowners, if that's acceptable to you.
I think that's appropriate.
Perfect. I will make that happen. Thank you.
All right. At this time, we'll open it up for further public comment. Anyone wishing to address the board, come to the podium, state your name, and sign in with your address. We have usually a couple of minutes for each person that would wish to address the board, and you should speak on anything within the Board of Zoning Appeals jurisdiction. If anyone would like to come, now's the time. Seeing none, I'll entertain a motion to adjourn.
May I ask one question
Yes.
before?
You may.
In the packet, there was the rules of procedure for the BZA.
Mm-hmm.
There was not an agenda item on here on them.
Was that just for the members to review?
Yeah, I just thought it'd be helpful for everyone.
Okay,
Hope it was helpful.
okay, because I had a couple observations that I'll talk to Mr. Delancey about, but.
Okay.
I know the changes that was discussed about the Robert's Rules of Order for small boards in the town of Fairmount were included in there, but when I went and read through, I saw a couple of other, maybe there is format considerations.
Yeah, we can talk about those. It was the board that actually made those rules. Okay,
That's it.
and anyone else? Okay, I'll entertain a motion to adjourn.
So moved.
And second, motion by Mr. Duke, second by Mrs. Rowan. Miss, sorry, thank you. All in favor, say aye.
Aye.
We're adjourned. Thank you all.
Good luck.